read interesting stuff, and it needn't be very focused. But when it comes to opinion writing, researching for an opinion, it has to be sharply focused on the question that you have to answer. So here are 4 questions that you need to ask yourself. What is the case about? What facts are relevant? What does client want? What am I being asked to do? Those are the questions. Are they very practical? It's at a very practical level. It is focused on the client's needs. So let's look at the basic steps. Most of this I dealt with yesterday, but I'm going to expand on some of them. First of all, analysis of fact. You must know the facts that gave rise to the issue or the question. Now remember, even when a client comes to you and says, we want you to resolve, or we want you to give an opinion about the effect of Section 13 of the Income Tax Administration Act. Okay, now, you're not going to be able to give an opinion just on what that means. It requires a context. There must be a set of facts. Your client must tell you, this is why we need to know. We've got an assessment we don't agree with. Something like that. And just to test it, let's test it. Let's say you go to court and you bring an application for a declaratory order. It's not opposed, but your notice of motion reads that you want an order, a declaratory order, as to the scope and meaning of Section 16 of the Income Tax Administration Act. No orders to costs. So you file an affidavit in which you say, I, the undersigned, I'm the CEO of this company, and I was discussing with a financial officer this new Section 16. We'd like to know what it means. Would the court please tell us? Well, guess what's going to happen? If you go to court with an academic question, the judge will throw you out with a punitive cost order, because that's not what courts are there for. There has to be a problem that needs to be resolved. There must be a set of facts. There must be an interest in the outcome. So you cannot indulge in an academic exercise going to court. Likewise, your client cannot come to you and say, we're just curious, tell us what this means. You cannot write a proper opinion. Of course, client comes to you and says, we read this piece of legislation, we're not sure how to deal with it. You can tell them, but it doesn't require a full-on opinion. The second thing is you must understand the question or issue. Now, one of the key approaches to research for an opinion is for you to narrow your research. What narrows down the research is your ability to understand the issue and focus your research on that particular issue. So if you get this wrong, you could carry out many, many hours of fruitless research for which you can't charge. Then you carry out an analysis of the law. You always commence with an analysis of the facts, because at first I told you leave the law alone. If you are misdirected as to the facts, you will commit a similar misdirection, which when you're researching the law. So get the facts first. Now, what is practical legal research? Now, how do you go about it? Very often as you progress in your careers, you might find a niche where you will develop skills to the point where you become known as an expert in that particular area. When you're an expert, say you're a tax expert, or you're an expert in competition law, or you're an expert in construction law, or banking law, or insurance, when you get an opinion and you are that kind, where it involves your expertise, it becomes very easy. You'll know you'll understand the issue, and you'll know where to start. But law is vast. The whole scope is so wide that you cannot be an expert on everything. Look, one day when you become a magistrate, you'll be an expert on everything. But until then, you are not an expert on everything. So you might get an area of the law. So you get a set of facts. You then contextualize it and you say, this involves competition law. Now, you don't know a lot about it. And it's a particular aspect of competition law. What do you do? Now, you have to go and start with a recent textbook. Why do you do that? Because a textbook is very useful for providing you with general principles. It is also a great source for primary sources, that is case law and statutes. So there are two benefits of starting with the textbook. The first benefit, it tells you the basic or general principles that are applicable. And it's important for you to know that because it then guides your research. Number two, it starts pointing you towards the authorities that you need. Your research has to be a narrow focus. You research only for the law which is going to be helpful in answering the question. That will make you quick and efficient. You begin with a preliminary identification of legal issues in the matter. You apply your knowledge of the legal principles to the facts to identify the following: the possible legal issues in the case. Now, I told you, clients don't often come and give you a perfectly thought out, ready-made legal question. That happens, especially where the client has a legal department and there's a lawyer there that has been through it and can come to you and say, here is a question, and they formulate it perfectly. That really happens. It's a joy to behold when that does happen. It cuts your work. What clients will do, they'll come and tell you there's a problem. They'll tell you what the problem is. They'll give you the facts. What they say to you is the question may not be the question. There may be a more relevant question that they didn't see. So your legal analysis will guide you towards the legal issues in the case. What are the material questions that need to be answered? You will also find key areas of law relevant to the facts. Now, when I talk about areas of law, what I am saying is that when you find you have to apply general principles, what you have to do is then go and look at the case law, because that is the law, okay? By the way, if it's a subject where you cannot find South African case law, then you are allowed, or you may look outside the country. There's a provision in our constitution that says you can do that. So, but I'm just warning you, if you have an opinion, especially if it involves commercial law, then look at the countries that are Commonwealth countries. I would start with England, look at the law, the case law in England, followed by Australia, Canada, India. Those are the 4 countries where you are very likely to find assistance. Okay. Those countries also use the common law system. And then you need to look for specific points of law. Now, there's a difference between general principles and specific points of law. The general principles give you an idea or inform you about what the law is. When you analyze the law, now you are saying, let me analyze the law in the light of the peculiar facts of my case. That's when you start identifying specific points of law. And those specific points of law must be relevant to the question that you have to answer in the opinion. Now, here are more guidelines. Consider the following questions. What essential areas of law are important to this case? Okay. What legal issues emerge from the facts of this case? So you know this is a matter involving competition law. But then you narrow this down. Your issue tells you that this involves price fixing. So now you narrow this to price fixing. So the legal issue that emerges is whether or not your client indulged in price fixing to the extent that it is outlawed by the Competition Act. What does client want as a solution to the problem? So you know that client will be facing a complaint to the Competition Commission. How does your client deal with that? Set out the processes. And your object is to show client how to resolve the issue with the Competition Commission quickly and cheaply. So you see, this is how you're thinking as a lawyer. Now you have to analyze client's problem and produce a list of legal issues that emerge. Write this down using numbered paragraphs. Then list these issues in order of importance. Then you research them in that order. It is important to do this, as you might find that it is not necessary to deal with all the listed issues once you dealt with the most important ones. Now, judges do this all the time. Those of you who are experienced trial lawyers or have done motion courts and appeals, you'll know that you identify issues that the judge has to resolve at the hearing. What the judge will ask you is, let's rank these issues. If there are 3 issues, which is the one that, if we resolve it, will be resolutive of the whole case? So we don't have to deal with the 2 other issues. A similar approach happens here. Always rank the issues. But there's one good thing about opinion work, is that you will rarely be faced with 2 or 3 issues. It happens, but mostly clients will come and say, this is the problem. They may not be able to put it to you in the form of a legal issue, but they'll tell you what happened. Contextualizing or categorizing the issue is very important. What area of the law does this fall into? What is the principal area of the law? And now you've narrowed the search. Which aspects of the issue are substantive or procedural in nature? Now, you will often get opinion work where the issue is purely procedural law, okay, not substantive law. That's the area of compliance. Those of you who do compliance work will come across this kind of opinion. Most of the opinions you have will amount to substantive law. As a rule, you must be focused on the legal issues that you have to answer, the questions you have to answer. Those of you who have a passion for law, you'll be tempted to explore interesting areas. As you're researching, you'll come across something very interesting. Like you'll come across a judgment and you'll think, this is interesting. And you'll read on and waste a lot of time, but it's irrelevant to your opinion. Whatever you research, keep it relevant. And how do you know that? How do you know it's relevant? A simple question. Whether or not this research is going to help you answer the problem. If it's not going to help you, just put it aside. If it's something so interesting, make a note of it, you'll read it in your spare time. Now comes a research problem, which people like me, when we were young practitioners, we'd never had. Have you heard of this thing called information overload? Lawyers are suffering now from what is called information overload. Where does that come from? It comes from the internet, as well as electronic or digital tools that we use in practice. Now it becomes so easy to find information, to retrieve that information, and to download it. This is one of the biggest time wasters ever, because there's so much information that you can access that you have difficulty. You don't know when to stop. You just keep researching and you keep researching, and the time just goes by. Carry out in-depth research only on specific issues and not on wide-ranging issues. And here's the trick. The idea for you is to stop as soon as you've got enough to answer the question. Oh, there may be more authorities, there may be more articles, there may be more views. Just, you don't have to canvass all of it. Just stop, okay? Now, I'll prove to you just how true this is. Let's go back to the SCA rules again and the Constitutional Court rules. Do you know, those of you who do this kind of work will know, in both those courts, they impose page limits on heads of argument. In the SCA, you are given 40 pages. That's double spacing one side of the page, only 40 pages. If you want more than 40 pages, you have to write to the president of the court and seek permission to file more pages. They punish you if you file more than 40 pages. The Constitutional Court, where you have to file written argument, they give you 50 pages. That's it. Now, I know as a lawyer that if you can't make your points in 40 pages, you are going to make a mess if we gave you more pages. And judges know this, but why did the SCA impose page limitations? I'll tell you why. With the advent of the digital research tools that we have, lawyers found so much authority that the heads of argument simply ballooned out of proportion. We saw heads coming in, appellants' heads, volume 1, volume 2, volume 3. Now, for God's sake, who's going to read all this? Those judges haven't got time to read all that. I mean, if you're sitting in the motion court in Johannesburg and someone gives you 60 pages of heads, Who's going to read that? So because of access to information, lawyers are beginning to write more than is necessary. Well, you have to limit that. And if you are writing an opinion as a practicing lawyer, you cannot afford to put in everything that you could possibly find in your research. Just research to the point where you can answer the question. Now, here's a very important point, and remember this. I often get asked the question, so how do you know that you've researched enough? How do you know that you can stop now? Simple. If you use the method of write as you research, you will know when to stop, because you are writing as you go. You wrote down the main facts. You analyzed the issue. You kept writing short paragraphs about what the law is. And in that process, the answer comes to you. Then you'll realize, hold on, I've got the answer. Now, when that moment happens, it's like an epiphany. You'll be researching and writing, and then the answer will come to you. And that is the most important part of writing as you research, because when you write, your brain is stimulated, you're thinking at your best, and that's when the solution comes to you. You'll see, that's it. I can tell you, no lawyer ever got an epiphany by sitting there with his arms folded thinking about it. You have to put in the work. And as you are working, the answer comes to you. When the answer comes to you, write it down immediately. Just write it. Then test it against the facts and the law. If that is what the solution is, the solution you're looking for, you can stop. Okay? So your client wants the answer. The next step is, you've got the answer, now look at the recommendations. Information overload results in lengthy opinions. Your client is not interested in it, I promise you. Clients want a short opinion that is fit for purpose. Now, as an attorney or an advocate, you will be responsible for obtaining a mandate. Your client is not expected to come to you with a well-formulated question. As I said, they are likely to bring a document and explain their problem in a consultation. You have to work out what the question is. It is crucial for you to understand the issue. Thereby, you will avoid the risk of misdirection. What you have to consider is, firstly, what legal issues emerge from the material facts, and how do you go about doing it? The first is a listening skill. Sit and listen. And I say, if you didn't learn how to listen, Mrs. Hussein tells me all the time that I don't listen. Well, she's talking nonsense. But the fact is, I actually don't listen to her when she's talking most of the time. You're a lawyer. You're not at home listening to a spouse. You're listening to someone who's paying you to listen. So sit back and listen. In commercial practices, you will always be confronted with documentation. Clients will bring you documents and say, these are the relevant documents. Your job is to make a note of all the facts, the material facts. I told you, you will write this down in a file. Always deal with facts sequentially. Sequencing is vital. And I always tell lawyers, make it a habit of thinking sequentially. When you write sequentially. When you prepare drafts, sequence them. Sequencing is what gives meaning to the facts. It helps the reader to understand what the point is. When you listen to your client, make a note of all the gaps that you see. Don't interrupt, let them finish. Then you ask questions to bring out the facts. Now, here's a trick. Never ask leading questions to your client. Always ask non-leading questions, open questions, get the facts from your client. The danger of using a leading question is that client will think that is the answer you want. They may not agree with it, but they'll say yes. The trouble with a leading question is that it always has the same answer, yes or no. So that's not helpful. Be careful of that because it's so easy to fall into that trap. Then clients will not know which documents are relevant. So there may be documents there which they didn't bring. Your job is to identify them and bring them along. Consider the legal principles involved. Now, I recommend you ask about the nature of the problem before consultation. Now, this is a very useful trick. It's a practical trick. It works brilliantly, and please do it. Train your secretaries. When client makes an appointment and they say they want to consult with you, just say to the, find out, Mr. Jones, what is this about? I'd like to tell Mr. Smith what you need. Now, sometimes it's not, clients don't want to say what the problem is. That's fine. But mostly they'll be quite happy to say, we need to consult about a tax problem or about a building contract. Okay, now, as I told you, you are not the expert on everything. When secretary tells you, please, it tells you, listen, Mr. Smith, Mr. Jones wants to consult. This is what he wants. What you do is you say, oh, this is about a building contract. Let me go and read up. Now, that's what a good lawyer does. A good lawyer goes and reads up on building contracts, so you know what the law, what the general principles are. There are the general principles that apply. Now, I'll tell you why this is brilliant. When client sits down with you in the consultation, you know what he's talking about. Now, people are not stupid. If you're listening to a client telling you a problem and you are at sea, you don't know what the hell this is, they pick it up. They can see you don't know what this is about. And they're not confident in you now. Okay, and that's bad. When you read up before client comes, you are already sounding like an expert. And that's the trick. If you have to sit up all night and read, that's what you do, okay? And it allows you to engage client meaningfully. You'll ask the right question. You won't be that attorney who asks a stupid question. And clients know it when you ask a stupid question. They'll be impressed with you. And it gives you a lead start on your research. You know what to do as soon as client walks out, okay? When you consult with client, it's always good to establish what's motivating them. Why do they need an opinion? What are they going to do with this opinion? How is the opinion going to help them? It's important for you to know that. When the consultation ends, summarize the facts for client and say, look, this is what I get from your consultation. Have I recorded it correctly? Have I understood it correctly? Now, if it is an important opinion, and well, they're all important, otherwise no one will waste their money. It's always a good habit to, after client leaves, to write down the material facts. And I told you, you're going to write as you go. You write as you read. Do a summary of the material facts, referencing the documents that you have, and send it to client and say, here is my summary. Have I left anything out? Would you like to add to it? Would you like to correct it? That's absolutely brilliant, because you've got a record after that of the facts as you've been mandated with. The issues must be established in consultation with client. It's a twofold mechanism, this. You want to understand the issue yourself, but you want to make sure that your understanding is the same as your client's understanding. If there's a disconnect between the two, you're heading for misdirection. And then I say, follow up the consultation with a recordal or memorandum. In this document, set out the questions that have to be answered. You must show an understanding of your client's problem. And here's a word of warning. Be alive to the fact that clients may sometimes give you facts that they believe will result in a positive outcome. This might be manifested from concealment to outright untruths. Yesterday, I gave you this scenario of politicians shooting their mouths off and then coming to you for an opinion. Well, that's where you start getting the facts selectively. But good lawyer will see it straight away. It shows, firstly, in the version of the facts. When the facts tell you that this is not likely to have happened, well, guess what? You know that they are withholding information. Don't be afraid to say, I need a complete picture. These are the gaps I need you to fill. Or I find this to be improbable. It's not likely to have happened. Let's test it. If this went before a judge will not accept it. So don't think clients come to you with the truth. They will conceal the truth if they're looking for a specific outcome from the opinion. Your job is to find out what happened. Now, Francis Bacon was very smart. He said, man prefers to believe what he prefers to be true. You know what? That's a politician. And you will get instructions from those people. Be careful. Now, I'm going to go, I'll deal through this. I'm going to go through this very quickly. This is now consultations. How do you deal with a consultation? Look, an experienced CEO will be very comfortable sitting and talking to you, whereas a new businessman or a small businessman, a small business, they may be a little more nervous about what's going on. It's very important for you as a lawyer to learn how to manage anxiety, make clients comfortable. I'm not going to go into details of that. You know what to do. Listen objectively. That's very important. Be interested in what your clients say. That's really important for you to be interested. Let the client do the talking. Okay. I've seen lawyers actually in a consultation say to client, oh, hold on, let me tell you what happened. That's nonsense. This is just a lawyer who's got a big ego and wants to show off his skills. Don't do that. It's not your problem, it's client's problem. So listen. Never attempt to show off your knowledge too quickly. That's a big problem, because once let's say a client tells you that, you know, we've been accused of price fixing spare parts in the motor industry. You'll say, oh, you know, there's a recent case of the Competition Appeal Court that deals with it. And now you start telling them about the case. Don't do that, because you don't know what the problem is yet. Get the details. Then ask questions. Don't ask leading questions. If you don't do that, you will not understand the problem, okay? Now, there's one thing that you should do. It's what modern lawyers do, 21st century lawyers do. You will consult in a boardroom, or you will consult on Teams or Zoom. If you're in a boardroom, it is very important, and I recommend that you do this. You must have a big screen monitor, a single monitor on the wall in the most visible part of the room. Usually it's on one end of the room, and your consultation table is positioned in such a way that everyone can see that monitor. That monitor must be hooked up to your office, your local area network in the office, and it must also be hooked up to the internet. It's very important. For example, you typed out the material facts. It will be brilliant if you put it up on the screen at the end of the consultation and you say, take a look. These are the main points, and it's coming up. Or at a convenient time when you can say that there's a recent decision of the Competition Appeal Court. So you pull it up. The judgment is on the screen, and you take client through it. It is so impressive. You look good. Clients love it. You involve them in the process. You get better instructions. Use the technology. If you are doing this in a Zoom meeting, I told you, have multiple screens, share, put the information on a screen and share it. Works well. Okay, now let's deal with fact analysis. The first step, as I always told you, get the facts, get the documents. The golden rule, this is very important for opinion writing. That's why I've highlighted it. The golden rule is use law to help you form an opinion on the facts, not the facts as an excuse to form an opinion on the law. Okay? So your opinion must be pertinent, or it must be relevant to the peculiar facts of your case. It is the facts that form the pillars that support your legal conclusions. Now, in anything you do as a lawyer, if you have to formulate a legal conclusion, and this is something we do every day without even realizing it. Someone tells you something, you say, oh, that's negligent, or that is definitely a breach of contract, okay? That's an assault, or that's unconstitutional. I mean, you do it all the time. But that legal conclusion is only valid if it is supported by a set of facts. Please remember that. Otherwise, it's just hot wind. Okay. So what do you do with the facts? I told you to make a list of the material facts. You wrote it down, you saved it. Good lawyer. Then go about going through those facts and discard what's not relevant to the question. It makes for an unnecessarily long opinion if you are going to include facts that are not necessary or relevant to the issue. Always arrange the facts and the documents in a sequence. Always write down what are the common cause or undisputed facts. What are facts that are not likely to be challenged? Make a note of those facts that may well be challenged. Remember, this is an opinion. You're not involved or engaged in a dispute with someone. But remember, most opinions happen because the parties anticipate a dispute or even litigation. So you test it accordingly. Now, here's a useful technique. Look at the facts that are relevant. Now ask if client can provide proof of those facts. You know, there's absolutely no point in writing an opinion based on facts which your client can never prove, because an opinion is useless, okay? Only accept a version. If there's going to be a version of facts, how did the problem come about? Here is a version of what happened. As a lawyer, only accept a version that is likely to have happened. Again, test it. Test it like a lawyer would. Listen to the story and ask yourself, if I put this before a judge, will the judge find that it is relevant? Or rather, will the judge find that in the circumstances of the case, this is likely to have happened? Remember the standard of proof on a balance of probabilities. So what are you doing? When you get a version, test the probabilities. Do not test the truthfulness of it. That's not the test. Truth is never the test. Because you will never know as a lawyer if your client's telling you the truth. But what you know as a lawyer is whether or not that version is likely to have happened. Is it probable? If it is not probable, you will not discharge an onus of proof and you will fail. Test it. Useless doing preparing an opinion where the version is not likely to have happened. And that is why you want to make a note of the undisputed facts. Because when you test your client's version, you have to test it within a framework of the undisputed facts. If these are undisputed, if these are the undisputed facts, how likely is client's version to have happened? Is it plausible in the light of these undisputed facts? Okay. Very often, in an opinion, you will have to make findings of fact. The findings of fact you make must be probable in relation to the circumstances of the case, can be supported by credible evidence. Okay, so the question is, can client prove these facts? Where's the evidence? Are there witnesses? Is there a contemporaneous document? Yes, you can prove it. Good set of facts. Can it pass the test? Is that likely to have happened? The probabilities, okay? Now you must be systematic. When you are researching and writing, I say there are 7 stages, and I'm going to take you through the stages. And when you do have to write an opinion in your offices, this is a guide. Now, I told you, you can't find precedents from which you can conveniently copy and paste, okay? You're a real lawyer, okay? You're not an ass. You're a lawyer, which means you don't copy and paste opinions. And I also say, I repeat again and again, through each of these stages, you will write as you go. You keep writing. Now, stage 1 is for you to understand exactly what client requires. Now, I've been through this. It means that you have to be clear about your instructions. If you are not clear about the instructions, call for further instructions. Stage 2, understand the question. Understand exactly what the issue is. Your job is to tell client what he or she wants to know. Your client wants an answer. And your client wants to know what to do. What are their remedies? What is your recommendation? Your client does not want to know the law. Your client doesn't want a lecture or a dissertation on the law. Your client wants a result. Okay. Stage 3, you must absorb the facts. You must have mastered the facts of your case. Okay. A good method is to write down in a chronological sequence, using numbered paragraphs, the material facts as you were instructed. Then ask 2 questions. Is this sufficient for me to understand the question? Now, the facts are crucial. If there's a gap in the facts, if the facts don't really tell me what the problem is, or I don't understand the problem in the light of these facts, then take instructions on the gaps. Make a note of where the gaps are, call for instructions, clear it up before you go any further. Okay? The 4th stage is the legal framework. By analyzing the facts and understanding the question, you will find yourself being pointed towards a certain area of the law. Now you will look at the law to help you answer the question. All legal research must be preceded by the factual research. Okay. The law will give you the material elements. The law will tell you these are the requirements if this is the remedy that you want. Write those things down as you find them. You are in the process of constructing a legal framework that will assist you to answer the question. Now, you see how important it is that if you read a judgment and you think it is relevant, before you move on to the next judgment, write a paragraph in your own words about what that judgment tells you is the law, and put in the reference, save it. Okay. Now, once you've done some factual and legal research, you need to review the case as a whole. Step back and consider what you have. Look at the facts, look at the law, and now review the question. Now, this is a very important part of research. I find that it is very, very useful where as you write, as you read, you are writing. You've now written a number of small chapters on the facts and on the law. Now sit back and ask yourself a simple question. Do I understand the problem? Do I understand the scope of the question? Is there an answer to that question? I must tell you this. It's a very useful thing for lawyers. You will often get asked this question. What is a good question? You often hear people saying, "Oh, that's a good question." You know, if someone says that's a good question, what they're doing is that they're trying to buy time to think about the answer. So they say, "Oh, that's a very good question, and I'm glad you asked it." Well, that's all nonsense. What's a good question? Now, I looked at dictionary meanings and so on. It didn't help until I was reading a biography of Albert Einstein. And Albert Einstein was asked that question. He said, you know, what do you think is a good question? And he said, a good question is one that is understood and it has an answer. Think about that. It's just brilliant. That's what lawyers need. For a lawyer, a good question is one that has that is understood and it has an answer. Okay? If a question doesn't have an answer, it's not a good question. Okay? Like someone says, what is love? I mean, that question doesn't have an answer. Okay? But as a lawyer, every question must have an answer. If it doesn't have an answer, there's something wrong with the question. Either you didn't understand the question, or the person asking the question doesn't understand the issues. Just remember that. Stage 6 is what the opinion is about. That's what you're getting paid for. You must answer the question. Even where the question or the answer is not clear, and that happens in law. In fact, the reason people come to you for an opinion is because the law is not clear. And all your research might point to the fact that the law is not clear. You must still exercise your judgment as a lawyer and form an opinion based on the facts and the law. So you come up with an answer and you make recommendations. That's what you are paid to do. Break up the problem into separate questions. Answer each question, and this leads you to the answer. It is never so simple that you get the question and you can say, I've got the answer. Okay? If it was so easy, you wouldn't be asked to write an opinion. Stage 7 is the advice. You do not merely formulate your opinion, you are expected to give client advice. Recommend what your client should do. Give client what they want. And that is good, practical advice. Not academic advice, practical advice that they can implement immediately after. Okay, now let's look at, in more detail, the legal analysis, the law. Okay. Now, the sources of the law, mostly, the most common sources, textbooks, you're familiar with journals. I don't know if anyone reads journals anymore, but all journal articles are easy to find. You Google them. I mean, behind me, I have a set of South African law journals. I don't think anyone buys them anymore. Academic writing, it's what you find in journals and textbooks. But you might find articles that get published from time to time by academics. They are compelled to write and publish articles, and some of them are really good. They're excellent for when you do research. Then there's newsletters, professional magazines, and bulletins. But now we come to the two most important sources of law. Everything else that I've mentioned now are what we call secondary sources. As a lawyer, you want primary sources, and there are two primary sources. That is the law reports, case law, and statutes. That's primary sources. If you want to find the law, that's where you find the law. Secondary sources like textbooks, journals, and so on, they help you with general principles and they point you towards primary sources of law. And you can use foreign law, foreign cases as well. I told you textbooks are good for commentary, useful summaries, and so on. And textbooks are very good at pointing you towards the cases, and you will find them in the footnotes. And I say always use the most recent textbook. Okay. As the law is stated, as at the date of publication of a textbook or commentary, you need to check. Now, if you look at any textbook, there'll be a date of publication there. Or the authors will put a note to say that the law is up to date as at, and they'll give you a date. So you know that the case law is only valid up to that point. But it's still very useful because let's say you find a case there, but the textbook was written in 2018. So it's up to date, say July 2018. All you have to do is take that decision, bring it up on electronic law reports, click on annotations, and a bar will drop down and you've got everything you want. The most recent decision on the subject, which approved of that case, will be in the annotations. And I say, check annotations for every case you reference. Now, this is so important. I'm just going to spend a minute on it. What are annotations? Those of you who used law reports, like the ones you see behind me, you would notice that in the heading of the law reports, there'll be in manuscript a lot of references. 1985 4SA discussed, or it will give you a reference and say approved. It's written manually because we didn't have electronic annotations back then. Those are annotations. What are annotations? Annotations is the history of the judgment. Remember, we use a common law system based on the principle of stare decisis, binding principle. So, in order to persuade a judge to accept your legal conclusion, you must be able to present that judge with a binding judgment. Now, that judge reads that judgment. If it is binding on that court, let's say you gave the judge, you presented an SCA decision in the High Court. The judge sitting in the High Court may not disagree with it, may not agree with it, he'll disagree with it. But that judge will tell you, you know, I don't really agree with this decision, but I'm bound by it. I'm going to have to apply it. Now, that's what you want. You want to present decisions that are binding and very authoritative on that particular subject. Now, with electronic annotations, it's very easy to find. In the past, or those of you who still have nota ups, you may be familiar with this thing called the nota up. It's published both by Butterworth and Juta. It is the annotations for the law reports. So let's say you're looking for a case on landlord and tenant. So you look up the subject index, you find landlord and tenant. It gives you various aspects, a breach, damage to property, things, huurgeld voorkoop, all of that stuff is there. And under those headings, you'll see some cases. Now that's where you start, okay? And then find the case that you want. Now turn over to annotations, find that case in annotations, and it will tell you up to the date when that particular nota up was written, if that case was referenced in other cases. So what you're really looking for, let's assume you found an SCA decision. It's 2019. Go to annotations. If you have electronic law reports, you'll see annotations in the head note. You just click on it, and it then brings up all the cases where that decision was referenced. Now, it does two things. It tells you if that decision was set aside. That's very crucial. You cannot rely on a judgment that was subsequently set aside in a higher court. You sound like a mampara when you do that. But you're also looking for a second thing. Where was this judgment approved? Now, remember, I told you yesterday, all you need is one decision, the latest decision of the highest court. And this is how you find it. Go to the annotations, look at similar court, in other words, other SCA decisions, and see if it was referenced or approved or discussed. If you see there's a constitutional court case where this case was approved, click on that. It opens up that judgment. You'll see it's a 2021 judgment of the Constitutional Court. Click on annotations there. Usually you will find no more references because it hasn't been referenced in any other judgment. And that's it. In 2 steps, you found the case you want. Easy, efficient, save you time, okay? And it is safe. You won't run the risk of relying on a judgment that was set aside. Ultimately, you are to look for the law in the most recent judgments of the highest court. You don't need more than that. If there are 10 other judgments, one from the Western Cape, one from Gauteng, another one from the Free State, forget, just don't bother. You've got the one case that you want. Okay, now comes the difficult part. You learned in university that what you want is the ratio of the judgment. And lecturers like using the Latin, the ratio decidendi, they will say, and they sound so clever. Actually, he doesn't know what he's talking about. Now, think about it. We've all read judgments, all of us, I hope. When you read a judgment, ask yourself, what's the ratio or the material law, statement of law that's in that judgment? Because you will not find a judgment anywhere where the judge has got a heading, ratio, and then tells you what it is and then moves on. Judges don't write judgments like that. You have to read the whole judgment and work out what the legal principle is, okay? Now, when you consult a judgment, always check if that judgment can be distinguished on the facts. If your facts are completely distinguishable, it may be relevant in the sense that it may be persuasive for purposes of a particular law point, but it's not binding, okay? Does the case squarely relate to the issue you are considering? If the case is applied to the facts in the problem before you, what would be the result? You see that now you are getting somewhere. If you read the judgment and you see that it is not distinguishable on the facts, then you see what was the result of that judgment? What was the order that the court granted? And why did they grant that order? How did the judge come to the point where he says the onus on the plaintiff was discharged? The judge will tell you that in the judgment. Now reverse engineer this thing. If my facts are presented to a court, will I get that result? If the answer is yes, you actually found the solution. You would have found the solution. Okay, that's what you want. And that's when you're writing this down, that's when it'll strike you, I can answer the question. I can solve this problem, okay? So what is the ratio? The ratio can be found only in any decision and reasoning on a pure point of law, and no case is binding to the extent that it decides a question of fact. Now, few cases are decided purely on a question of law, and the same can be said about fact. What you can expect is to find points of mixed law and fact. How did the judge apply the law to the facts that were found? Now remember, if you read a judgment, which I told you is a very good example of an opinion, what you will do is you will see when you read the judgment that if there was a dispute of fact, the judge will first resolve the dispute of fact. The judge will say, I find that the plaintiff's version is likely to have happened, and I accept the version of Mr. X. Or the judge will say, I reject the version. So if the judge cannot decide the facts, or the judge rejects the facts, that's the end of the case. There's no point in applying the law. So the judge will first make a finding of fact, then look at the case law. What you look for is the reasoning that led to the conclusion. That is the ratio. Judges never express it, okay? You have to dig it out from reading the judgment. And be careful. There's this thing called an obiter dictum. This is just a passing comment that the judge may make. Sometimes they are relevant, but they are not binding. Now remember, ratio is really the finding of law. It is not the finding of fact, because you can't have a judgment that is binding on the facts, because cases are all different. The facts are different, okay? But the law has to be consistent. Okay? That is why the ratio is the law. And I found this interesting reference. I can't remember where I read it, but someone wrote, the ratio of a case is what a later court decides it to be. It's so true. When you look at, that is why you need to look at annotations. When you see that the case you read, which you find is relevant and you'd like to use it, look at the cases where it was referenced. Click on that, see what the judge in that case had to say about this, the previous case. And the judge will actually tell you what the ratio is there. So it's a convenient way to find out what the ratio of the case is, okay? I've been through annotations. Do not write opinions if you did not check the annotations. And of course, don't you dare appear in court with heads of argument referencing cases and you did not check the annotations. You'll get seriously embarrassed, because you'll refer to a case and you will pedantically tell the judge that your lordship is bound by this judgment and that your lordship has to find in my favor. And then the lordship looks up and says, but listen, was this case not set aside by the Constitutional Court in X versus Y? I tell you, you know what that is? That's the equivalent of you standing up in court and your pants falls down. That's what it is. You'll be so embarrassed, okay? You better pray your client's not in the gallery, okay? How do you avoid that? Check the annotations. You need to have a plan. You can't have a hit and miss research approach to research. We did that at university. You went and you read cases and cases and cases, and you might come across one that might be relevant, and then you mark it and you put it aside. Can't do that anymore. You can't have a random approach. It wastes time. This is how you do it. Let me show you what you do. And you can use this as a guide. Understand the issue first. Do you have a general understanding of the topic? Did you read the basic textbook? Are you familiar with applicable legislation? Now, let me pause there for a moment. You know what I found with lawyers, and I've been with them for more than about 50 years now, if you consider university. I find even more so these days with younger lawyers, and I'm sure most of you here are very young people. They hate reading legislation. They don't read legislation. I often get asked questions by attorneys and junior advocates. They say, I've got this problem. What do you think? Or can you assist me? And I'll say, listen, did you read the act? They'll look at me and say, oh, the act. I'll say, listen, I'm not telling you what the answer is. Go and read the act. Okay, so off they go, they read the act. And they never come back to me because the answer was there. Please read applicable legislation. It is not the most exciting thing to read. I'll give you that. I mean, it isn't. But you're a lawyer. You have to do that. Well, by the way, judgments are not the most interesting things either, but you have to read it. What are the sources that will assist you to answer the question? I told you, always look at primary source for the purposes of your opinion. Legislation and case law. Always keep a reference of each source. Now, what we call a research trail. Now, if you use the write as you research method, where you write a short chapter and you put the full reference of the case, you will do very well. Why do you need a research trail? It's because when you write your opinion, if you didn't keep references, it means you have to go and find the bloody thing all over again, and you are just going to waste more time. So maintain a research trail. And I've been through this a million times. Write as you research. If you don't do that, then you are going to bleed money. You will become insolvent. Keep relevant notes. This is where your writing as you read goes. There's nothing more relevant than a chapter that you wrote in your own words in which you can explain the relevance of a particular judgment. There's nothing better than that, because in writing that chapter, that short paragraph, you demonstrated your understanding of the law. If you didn't understand the law, you are not going to be able to write a short paragraph. You will struggle. When you struggle, you know that you missed the point or you need to go back. I told you copying and pasting is of absolutely no use. Just don't do it. Keep meticulous and full notes as you go. You do not want to come back and look for it again. Now, if you don't write as you research, I promise you, you will have to go back to those judgments. You'll have to go back to the textbook. You'll have to keep going back because you can't remember. You may not have understood it the first time. So you need to go back. It is a serious waste of time, okay? Keeping notes during research prevents you from having to do the research again. The notes must be clear, well organized, and easy to follow. Keeping a checklist for each legal issue is a good idea. Now, I'm saying you can do better than merely keeping a note. When I say keep notes, I mean you write down as if you are going to put this in your opinion. You'll write down exactly what you say, what you think, in your own words, what that judgment tells you. And it works brilliantly because when you're writing, you're testing your understanding. Okay, don't fool yourself. Don't read the judgment and think, oh, I know what this means. Yeah, I can remember it. I'll understand. Try writing it down in your own words, then see what happens. Now, electronic sources. You need to keep a note of the database you searched, any limitations to its scope, specific sources within databases, research terms that you used, how you updated the legislation and case law found, and the date of the electronic research. Now, these are all the things that you would do when you are using electronics to do research. Now, when it comes to databases, it's very important, especially in commercial matters, these days. In fact, the days of hard copies is gone. When a client walks into your office these days, they will tell you that we have documentation. Where's the documentation? It's on a hard drive. They will say, we copied it. Here's a copy for you, or here's the link. You can then get, and here's a password. You can get access to the information. So you will end up researching the facts, documentation on a database, a hard drive, okay? You'll have to make a note of whether of the format. Is it in native format? Do we have to reconstruct the data? So this is the reality of the modern world. And again, the trouble with electronic databases is that they're so crammed full of documents. Okay, so you'll require, for instance, if and please do this. If client ever comes to you and says, here is the database, here's a link, and here's a password, you can access the data. You must just stop them and say, oh, hold on. What is this database? What's on it? Does it contain metadata? Have you selected only the relevant documents for me? If not, do you have an effective search engine or a search tool so I can access what I want? Now, if you don't do that, you are going to get into someone's database and you just won't know what to do. It's going to be overwhelming. You'll be wasting time. Just put it on client. Say, look, I need the documentation. The onus is on you to find it and present it to me so that I can access it immediately. Okay. Now, here's some practical methods. Gather the facts and identify those facts that are most relevant. Analyze legal issues involved and identify the legal questions that need answering. Then research law, fact, and then come to what I call a preliminary conclusion. Now, this is how lawyers' brains work. This is what good lawyers do. When you get a question, you might, if it's an area of the law that you know well, you will formulate what is called a prima facie view. Judges do it all the time. They read the pleadings in chambers or the motion papers or an appeal record, and they formulate a prima facie view. You will do the same thing. It happens to you. So what you should do is make a note of what you believe is the answer. Now, you may not have even started any research. You've got a prima facie view, write it down. As you research, you might find yourself having to adapt that prima facie view. So you will change it as you go along. At the end of your research, you will either have confirmed your view, so your prima facie view becomes your final view, or you might have rejected it and come up with another solution altogether, okay? Now, here's a sickness that I need to address, because it's like a plague. It inflicts all of us. It's called passive reading. This is where you read large amount of text and you don't read actively. You're just reading. You're not applying your mind. You're not thinking about what you're reading. You don't see any inconsistencies. You don't see ambiguities. You don't see the relevance, but you're reading, okay? Don't do that. You want to read actively. So if you're reading actively, this is what you're doing. You're asking, how does this fit into what I have already found? Now, here's the thing. When you're researching, I told you, you will come across information overload. There'll be a lot of cases that you can read. There'll be many textbooks. There'll be lots of legislation. So what do? Active reading means that you're going to ask these questions as you research. How does this fit into what I've already found? Why do you ask that question? Because there's no point in researching something that doesn't add to what you already have. Now you're just duplicating, okay? Does it add to my existing knowledge? Does it reveal new issues to be examined? How does it help me to answer the question? Where is it likely to fit into my answer? And then stop. If you can answer those questions, stop and write a short paragraph. I recommend that while researching the law and having asked these questions, you immediately write a short paragraph and save it. It reduces time. You might conveniently copy and paste from your saved notes instead of formulating the argument afresh. Remember, you wrote it down already. And this way, and this whole idea of writing as you research has an important advantage. It compels you to think. You cannot write a short chapter if you're not applying your mind. It's like scrolling a judgment, click copy, click paste. When you do that, you didn't apply your mind. No one understood the law by copying and pasting it. Yes. I told you, you start with secondary sources. You start with the basic textbooks. Then you move to primary sources where you will concentrate your research. And here's the rule. The conclusions of fact you rely on must be supported by the evidence before you. That's a finding of fact. The conclusion of law you come to must be supported by those facts, okay? By your findings of fact. Okay. Betty, it's 12:30, and we've had no load shedding here, so the powers that be are smiling on us. Let's take a 10-minute break, okay? What time do we start again, Betty?
Judge, 10 to? It's now 12:36.
Okay, so 12:50.
Yes.
Right. Okay, we'll resume at 12:50. Right. Right, can I begin? Can I
You can
carry on,
continue,
Betty?
Judge. Yes, you can.
Okay, all right. Now we conveniently come to composing the opinion. You would have noticed that I spent most of my time dealing with the techniques in applying yourself, applying your mind, and researching efficiently. That's really where most of the work goes. Composing the opinion is the easy part. Writing it becomes easy. And it becomes really easy when you start, when you used the write as you read method. Simply because in any document you produce, be it an affidavit, particulars of claim, heads of argument, an assignment at university, the most difficult thing to do is to come up with your first draft. Once you have the first draft, it becomes easy after that. When you have a first draft, you start from the beginning, work through it, refine it, amend it, and eventually you'll get a draft which will ultimately be the one you sign off. But if you didn't write as you read, it's going to be a long and arduous process for you to write an opinion. But let's look at the layout, okay? The first part, the first rule is always commence the opinion by setting out the facts as you have been instructed of them, or as from those instructions you assume those facts, what the facts are. Highlight and separate out the material facts that you think will be relevant to the legal issues. If you do not do so, you may overlook an important fact or focus your research on a less relevant set of facts. Separating out the facts helps to ensure that your research and analysis is more structured and streamlined and efficient. Basically, the facts are the foundation of the opinion itself. Okay, so you start with an introduction. I told you very short. Someone asked me yesterday, what goes into a short introduction? Simple. You'll have the heading that says introduction, and you say something like this. This is an opinion on whether or not client reached the Competition Act where the client is accused of being accused of participating in a cartel. That's it. You don't have to say more than that. That is all you have to say. 3 lines, 5 lines at the most, that's it. Because lengthy introductions are quite useless because you will have to, you inevitably have to repeat it in the rest of your opinion. So don't waste your time and don't waste the reader's time. Analyze the facts meticulously and objectively. You never generate any extra facts or reinterpret, or a very bad habit, lawyers do it all the time, shoehorn the facts into your particular view of the case. So you find a case, it's not on all fours. The facts may even be distinguishable. So what do? You panel beat the facts a little so that it fits the case. That is the worst thing you can do because you get found out. Your job is to set out the facts objectively, accurately, and dispassionately as possible. Okay? Remember, unless a dispute of fact is the opinion that you have to deal with. The instructions that you receive, those facts that came from client, or if you interviewed witnesses yourself, that happens. Write them objectively, dispassionately. Now, here's the problem. let's assume your client gives you a set of facts and you're not satisfied that this is a plausible version. You know, as a lawyer, that you cannot rely on this version. Or you could write an opinion on it, based on it. That's fine. But there'll be consequences later. If you have to write an opinion based on a set of facts that is not plausible or likely to have happened, then say so. Don't be afraid. Say it in your opinion that should this version be tested in court, it is not likely to be accepted, nor is it likely to persuade a judge to accept it. Say it in the opinion. Don't be afraid. Always set out the facts sequentially. It will assist you where the issue might involve statutory time limits and time bars. Now, very often you get opinions about the validity or effectiveness of a time bar. Where do you find these things? Mostly, and most opinions come from this, and that's insurance. Insurance policies have time bars in them. For example, if you do not report an accident within 3 weeks, then your cover has lapsed, stuff like that. Where there are time bars involved, strictly sequence every piece of fact, then analyze it, okay? In a commercial case, sequence documents and supporting evidence. If you believe that you have not been given enough facts in the questions that are crucial to the central legal issue which you have to resolve, identify the additional information you require. You'll have to explain to client how it could possibly affect the legal opinion, and now you want further instructions, okay? Now you know why it's so useful to summarize the material facts that were given to you, and in a form of a memorandum, you send it to client. I have dealt with this ad nauseum. Never copy and paste anything into your opinion, okay? Your purpose in setting out facts is that it assures client, this is very important, where you must set out the facts accurately. That is why we start with it. We start with the facts, because client must be satisfied that the facts that you applied are the same facts that client instructed you with. You didn't go off at a tangent. You didn't get facts from somewhere else. It's the same facts. In other words, the facts that you summarize very objectively and dispassionately in the first part of your opinion will be consistent with that memo you sent them, which they approved of as the facts. It also tells the reader that the opinion is based on these facts and not any other facts. It's very important for the reader to know that you formulated an opinion and answered the question based on this as a set of facts. That's the first part. When you've stated the facts, now state the issue, okay? This part of the opinion is you set out the question that the client has proposed, or which you see as arising and which you propose to answer. The question must be stated simply, without ambiguity. The reader must understand the issue before reading on. Very important that the reader knows the facts, understands the issue. If there's more than one legal problem or issue, state them all with equal clarity. And if it's applicable, rank the issues. The most important issue is this issue, followed by the next two issues. Okay. And now, how do you record, or how do you write the issue? An effective method involves stating the issue in the form of a question or question. It helps clients to understand the issue, and it helps you to answer the question. It is also a good technique to use these questions as subheadings, in your opinion. So when you say what the issues are, for example, the issue is whether or not client committed the offense of price fixing. You see, it's a question, okay? Whether or not the contractor was entitled to repudiate the contract. Question.
Grandchildren.
Are we, or a question, can client claim a VAT return on this transaction? It's in the form of a question. Depending on the level of your existing knowledge and the question, you may already be able to identify the main issue and prioritize. Do not treat, I told you, there will be a preliminary analysis or a prima facie view. I told you you should write it down. But remember, it's not cast in stone. You must be prepared to, as you research, realize that your prima facie view was actually wrong. Okay. Always reassess your preliminary view of the issues once you completed more research. That's the way it works. Understand the issue, formulate a view. Now do the legal research. Your view may have changed. Okay. Now is the third part, advices on the law. There are many ways to approach this. The proper way is to start with the cases and work through to reach a deduction as to the principle of the law. Okay, so you've stated the fact, you've stated the issue. Now you're going to deal with the law, or what we call the rules. Now, very often you formulate a value judgment as to what the conclusion or the legal conclusion ought to be from first principles and moral feelings, and then you search for authorities to support the conclusion. Now, that's how lawyers think. You know, the fact is, you cannot, or you never commence any research with a blank slate in your mind. It doesn't work that way. We are human beings. We have a brain. That brain tells you from the experience you've had, from the knowledge that you have accumulated, that this is the view. This is the prima facie view. Now you go and research to see if that view is confirmed, or perhaps it will be rejected. When you advise on fact and law, it's often not a good idea to be too positive. You know, when you get asked to give an opinion, it's because the law may be in a state of flux, or it's doubtful, or it may be doubtful. A good lawyer in this section, when dealing with the law, will say so. You'll say that this is a gray area, and say why. There are conflicting cases. There are conflicting provincial court cases. You must, you will justify your conclusions with reference to the facts and the law. I say the process of reasoning must follow, and you must come to an opinion. You can say that this is a gray area. There are conflicting decisions, but then you'll say the decision in the Gauteng provincial division is preferable, and I base my answer on that judgment. Always state the law clearly and simply, okay, without oversimplifying. The rule is for you to provide as much detail as you consider reasonably necessary for client to follow your reasoning and your arguments. Now, how do you deal with this? Easy. When you read the case, write down a chapter. That way you understood it, you can express yourself, and you can just incorporate it into your opinion. Always include references to authority within your text. I say avoid footnotes if you can, but if there are a number of cases or there are many references, then perhaps use footnotes or use a reference page, okay? But I prefer putting the case in there so the reader doesn't have to go and look somewhere else. The fourth part is the conclusion. End your opinion with a conclusion that directly addresses the question. So in other words, if you have a sound understanding of the question, as I told you, a good question is one that is understood. Then answer that question unambiguously. The conclusion must draw together and summarize the essential results of your arguments and the analysis in the body of your opinion. What you do not want to do in answering the question, repeat the whole argument again. I told you, you need to keep your opinion short. Long opinions don't work. The conclusion therefore provides the ultimate answer to the question and resolution of the problem. It should neither include a paraphrase of your introduction nor introduce new material. Now, there's a habit. Some people would come to a conclusion and in expressing the conclusion, end up repeating the arguments or bringing in something they said in the introduction, and it's just a waste of time. It's a repetition. It's not necessary. Then you have this sitting in the fence, on the fence problem. I've seen opinions which were complex. The law is a gray area. It's not a simple answer. And then the opinion goes this way and that way. There's this approach, but there's also another approach. It is not clear which is the correct approach. There are conflicting decisions and so on. You are nevertheless expected to come up with an answer. You can't leave the opinion, you can't conclude that I'm unable to answer the question. That's not a good opinion. You know, you must have heard of this thing called absolution from the instance in court. It's where the judge does not have enough information or evidence to resolve the dispute. The plaintiff didn't put up enough facts, and the defendant didn't help either. As a policy, we don't like granting absolution for the simple reason that it doesn't resolve any issues. The parties walk out of court having spent an enormous amount of money on the case, and they've got no result. It's the same with an opinion. You charge a lot of money for an opinion. You need to give your client a result. There's nothing wrong in saying it's a gray area. There's absolutely nothing wrong in pointing out the conflicting authorities. That's precisely why they came to you for an opinion. Apply your mind as a lawyer. That is why I say, from the moment you start, write as you go. Just keep writing paragraphs. Your brain starts ticking. The brain's a wonderful thing. The answer will come to you. Nobody found a solution by sitting down. This thing about go to bed and you find the solution in the morning, that's nonsense, okay? I don't know a lawyer who went to bed and slept when he's still mulling over a problem. I mean, I would stay up all night thinking about it. Oh, and by the way, here's a practical tip. You can laugh if you want. Good lawyers always keep a pen and some paper on the bedside. I'll tell you why. Some of your best ideas happen when you're lying in bed thinking about this thing. And suddenly a point hits you and you think, right, that's it. Good lawyer gets up, switches on the bedside lamp, and writes the point down. You know, the first time my wife saw me do this, she thought I was mad, okay? Then she got used to it. I'll tell you why you have to write it down. If you don't, the next morning, you will remember that you had a brilliant point last night, but you can't remember what it was. It's gone, okay? So write it down. Clients appreciate that you came up with an answer, you applied your mind, and you made recommendations. Where your opinion, as I told you yesterday, is lengthy, prepare a summary or an executive summary, 2-pager, point form, reference to the law, answer to the question, recommendations. Very brief, to the point, place it on top. Otherwise, I told you the best method, introduction, issue. Then you say, here's my finding, here's my recommendation. And now you deal with the rest of the opinion. Now you go, facts, the issue, the law, conclusion, recommendations. Okay. The summary should do 2 things. A short summary of your overall conclusion without client having to read the full legal analysis. And secondly, you give a preview of the final answer. It will assist clients in understanding your detailed analysis. I find that clients like it when you give them this kind of summary. That's the first thing they will read. Then, if they want to read your reasoning, how you applied the law, they will now go to the main opinion and start reading it. But when they do that, after reading your summary, they would have been placed into context. It's context before detail. It means that the person reading it, a layperson, will be able to follow the argument because they have a good understanding of the context and they know where you are heading. Where do you place it? This paragraph or the 2-pager is written last. Obviously, you write that last. In fact, the first part of your opinion, if you are not using a separate summary document, then you go introduction, issues, answer, recommendation. That goes up front, but you write that at the end. You write it last. So you write the whole thing through to your conclusion and recommendations, and then you can copy and paste from there, but put it up front. That's what clients want. Where you wrote a 2-page summary in a complex and a lengthy opinion, bind it separately or present it separately as a standalone document, okay? So if you're doing this electronically, as you will, you'll email your opinion as one document, and you'll email the summary as another document. It will be in a PDF form, and you'll send it as 2 separate documents. Okay, now we come to the final phase. This is the fun part, okay? Or it can be a nightmare. When you've written your opinion, you have to revise it. And I'm saying never skip the step. I don't care if time has run out, you'll have to find the time, never skip the step. I know practitioners, over the years I've come across them, who, having completed their opinion, sit down and revise it and decide that they were completely wrong. They realized they were wrong. Now, I'll tell you what happened. I was in a very big law firm when I was an attorney. I was at Edward Nathan, and they briefed a QC that time, Arthur Suzman. I can mention him because he's deceased. Arthur Suzman QC was a highly regarded advocate, and he was also the most expensive advocate in the country. He charged enormous fees. So we went along to him to get an opinion about the customs and excise duties on an electrical component. So took client along, and we took this electrical component to him, and we briefed him on, we want to know, is this thing subject to excise duties, and in what percentage? That was the opinion. He wrote that opinion, sent it to us, charged an enormous fee. 2 weeks later, an envelope arrived from the QC with another opinion, a second opinion. It was a different opinion, and there was a short note that saying, jettison the first one I sent you, use this one. Well, we were quite happy with that. We didn't have a problem, except that he charged another enormous fee. Now, that we were not happy with. So you see, even the best in the business can read an opinion they wrote, and in revising it, decide, oops, I was wrong. Now you also know why we have appeal courts. When a judge in the High Court gives a judgment, his opinion could be wrong. So we go to the SCA, where they'll come up with an opinion and say that judgment was wrong. Then you go to the Constitutional Court. They read this thing from the SCA, and they said, no, the SCA is wrong. The judge, our quo was correct. You see, this is how it works. So your opinion, at best, must show that you applied your mind to the facts and to the law, and you have a well-reasoned conclusion. That's all you can do. You cannot do more than that. Now, a very good technique is for you to take a break from your work. You never read your opinion as a revision straight after you finished it. Bad idea, because you may still be under the influence of your thought processes there. You'll be less objective. And it's very difficult to be objective about your own writing. Leave it for a day or two if you've got the time. Then go back to it. Sit down, have a cup of coffee there, and start reading. You'll be amazed at what you will find. You will find, apart from typos and spelling errors and so on, that's normal. You can fix that. But you might find that your conclusion is wrong, or your conclusion needs to be amended. Now, can you imagine if you found that out after you delivered the opinion? It's embarrassing to say, hey, listen, ignore that opinion, here's a better one. Now, Arthur Suzman QC could do that because he can get away with it, okay? But not you. So what are you checking? Check if you carried out client mandate. Did you answer the question? Did you provide recommendations? You check for accuracy, check your references, see that there's no typing errors in the references. You know that there are many people who suffer it's a sickness. It's called numerical reversing. You reverse numbers. So if you have to write 1963, it comes out as 1936. It happens to very smart people. So read it through, check if there was a typing error or a reversal or something like that. Is the layout user-friendly, easy to read? Is it attractive to the eye? Your opinion must not be a single page of small writing, no spacing. It looks busy, it looks awful. No one wants to read it. And this is a difficult question. Are you persuaded by your own conclusions? It's very hard to be objective if it's your conclusion, but you can check two things. Do the facts support that conclusion? You can be objective about that. Does the law support the conclusion? And here's a good one. Debate your conclusion with someone who proposes an opposite view. In other words, get someone to play devil's advocate. But I think it's also a good idea to ask a colleague to read your opinion. What do you think? What do they think? It may be a senior colleague, maybe even a junior colleague. It's always a good idea to get them to read it. You will obviously do this under a strict confidentiality regime, but colleagues know that. You know, your colleague in the same firm is subject to the same requirements of privilege, so it's not a problem. It's only when you bring someone from another firm who says, you know, read this thing, what do you think? Now, I can tell you at the bar, the advocates have this collegiate system. It's been there for centuries. It works brilliantly. At the bar, when one advocate consults another advocate, that advocate cannot say, listen, I'm busy, man, Futzak, come back next week. You don't do that. You say, come inside, John, sit down. John says, I've got this opinion. Why don't you have a look? Sure, I'll take a look at it. I'll come back to you this afternoon. You know, that's how lawyers work. It's always, and also when you're writing the opinion, let's say you've come up with a legal principle and you think you found the answer. Discuss it with another colleague, because as I told you, when you write as you research, it forces you to think. There's one other method that stimulates thinking in a way that you never expect, and that is debating it with somebody. Use that person as a sounding board. Just have a discussion and suddenly the lights go off in your head. You'll come up with points you never thought of just by discussing it with someone. Okay? So that's a very important thing to do.
Baba, you too?
What's happening, Betty? Betty, is there a problem? Okay. What's the problem?
No, there's no problem. Sorry.
Okay. Okay. I don't think you muted. Okay, I see your mic is off now. Okay. Okay, let's look at some sensible advice. It is not possible to be a successful lawyer in the absence of, I say, excellent literacy skills. You can't write anything, let alone opinions, without sound literacy skills. And, you know, I've been teaching lawyers for more than 30 years. And unfortunately, the standard of literacy has dropped. It's one of our biggest problems. You see it in court. I mean, I'll give you a good example. This advocate in the Senzo Meyiwa trial, he's cross-examining this forensic expert, police officer. And he wants to tell him that you made a shambles of your investigation. So he doesn't know how to formulate the question. He's cross-examining, so he's supposed to ask a leading question. He's supposed to say to the police officer, Sergeant, you made many mistakes. You made a hash of the investigation. Your investigation was inconclusive. That's a line that he wanted. He couldn't work it out. So now he's stuck and he looks at the judge and he tells the judge, my lord, what do you say? I want to say that he effed up the scene. But he didn't say effed up. He used the actual F word in court. When I saw that, I was stunned. Okay, this is a very patient judge. If I was sitting in court, I would have had his guts for garters. How dare you speak like that? And then comes the LPC, sends out a directive that lawyers must observe the proper decorum in court. What a lot of nonsense. Do we need a reminding? Do we need to be reminded of that? No. What's the problem? Poor literacy skills, okay? So how do you improve your literacy skills? You can't do it by attending a course. You do it. You acquire those skills. You acquire them. If you worry that your literacy skills, your analytical skills are not up to standard, do not fear. I mean, there are a number of you here who are young people, and you are wondering if you'll be able to apply yourself the way I've been telling you. Okay. But here's the good news. You will be. You can do it, provided that you improve your literacy skills. So how do you do that? Simple. You have to read a lot. Now, yesterday, I promised you that I'll recommend certain books that actually will show you how logic and reason is applied to various scenarios or sets of fact. And there are a number of authors who do this brilliantly, okay? The first one I'm going to recommend is Malcolm Gladwell. Malcolm Gladwell, okay? There's his name. These are not novels or books in the sense that they cover a single subject. These are copies of excerpts or articles that he wrote in various publications, prestigious publications, okay? The thing about Gladwell is that he takes everyday occurrences and then through the application of logic gives you a completely new perspective of it. And it's brilliant writing. He's written 8 books. They are all worth reading. I've read all 8 of them, okay? I would recommend that you read as many of them as you can. Read all of them. I think the first one he wrote was Tipping Point. Brilliant book. Then he wrote a book called Blink, B-L-I-N-K. Now, when I read that book, I thought this book was written for lawyers. Because what does it do? It talks about what happens when human beings have to make decisions quickly, split-second decision. Like he takes an example of a police officer confronting a criminal. When does he make that decision to shoot the criminal? He's got to reach for his gun, and then he's got to shoot this person. He's going to kill that person. When does he make that decision? He doesn't have time to sit and analyze the facts and come to a reasoned conclusion, but his brain goes into a certain mode, what they call the blink mode. Now, it's brilliant stuff. You should read it. His other book is called Outliers. It's about why do super successful people get successful. For example, he writes about why did Bill Gates get so successful. And I'll tell you what, Bill Gates is a voracious reader. He would read at least 2 books a week, okay? Then there's his more recent book is one called David and Goliath. That one you should read as well. So it's Malcolm Gladwell. All the books are available locally. And these books are so popular, you can find them in second-hand bookstores. Cheap. You can buy one for 20 Rand, okay? So I would recommend that. Then there's these two authors called Stephen Levitt and Stephen Dubner. They wrote a book called Freakonomics. Okay, Freakonomics, not economics, Freakonomics. Brilliant book. Also, lots of logic and reasoning in it, and entertaining. They also wrote a book. Their follow-up was this one. It's called When to Rob a Bank. Okay, yeah, there we go. Irene Power says Blink is available free on Kindle. Okay, but I suppose you have to first get the Kindle. When to Rob a Bank. Okay, I mean, this is a book for South Africans. Okay, we all like to rob banks here, but it's a clever book. It's a very clever thing. It's about how banks work out when when they're going to be robbed. It's very clever. Then there's an author called Julian Biagini, if you can see that. It's Julian Baggini. Now this book is called, and you can see, it's called The Pig That Wants to Be Eaten and 99 Other Thought Experiments. He wrote another book. It's called The Duck That Won the Lottery and 99 Other Thought Experiments. This author, those two books, when I read them, I also thought it was written for lawyers, because what he does, he engages in thought experiments. So he asks you to, he puts a proposition and then gets you to formulate a view about it. Then he'll tell you that the view you formulated is likely to be the following, and he'll be right. Then he'll tell you, actually, you are wrong. And he'll tell you why you were wrong. Then you start thinking, of course I was wrong. Then he'll tell you, no, actually, you were right the first time. You know, it's that kind of mind juggling. It juggles with your mind. It is totally absorbing. And it's just small experiments. It says 99 experiments, okay? And that's what it is. There's 99 different ones. And you can read one or two a day. And it's perfectly absorbing and very clever writing, okay? Then there's this book by Rolf Dobelli. It's called The Art of Thinking Clearly. Rolf Dobelli, Dobelli. Now, this book is not available on our bookshelves here. You can buy this on Amazon. Amazon's got it. What this book is, there we go. Freakonomics, also available as a free sample on Kindle. You see? Very good. Now, The Art of Thinking Clearly, there's a book written by Daniel Kahneman. It's called Thinking Fast and Slow. Now, I don't recommend that book to people who don't read regularly because it's quite dense and involved. This book, but it's a brilliant book. Kahneman won the Nobel Prize for Economics. This book actually is a simplified version of that. And it's quite entertaining and a wonderful read. And it shows you how the human brain works. And it helps you to become more critical and more logical in your thinking. A very good book to read, okay? And then there's a book I always recommend. There's this author called Bill Bryson, big writing, Bill Bryson. This book, A Short History of Nearly Everything, if you haven't read it already, then you're not a very literate person, I can tell you, because this is a worldwide bestseller. It's a brilliant book. It tells you, it is a classic of plain language writing. He takes all these mysterious things like the Big Bang Theory, or the theory of relativity, or evolution, and he explains all of it in such simple language that you read this and you go, oh boy, now I understand it. Now I know what that means. It's just absolutely brilliant. Okay, that's a good book to read. And of course, I'm not going to sell myself short. Here's my latest book. Uh, it is Trial Advocacy, The Art of Persuasion. I wrote this book. It is the only book on this topic in the country. No one's written a book like this. It's about being a good trial lawyer. It covers everything. It's practical. It's like what I did here. I tell you what to do and how to do. It just became available last week, hot off the press. Betty will send you the order forms. It's worth reading if you are going to appear in court. Okay. And of course, this book is quite famous. Practical Drafting Skills. It's prescribed by the Legal Practice Council. If you want to draft without a precedent, this is where to go. And there are attorneys, many attorneys who use this on a daily basis. They stopped using precedents. It's brilliant. That's what you want. Okay. So the secret to your success is for you to commit yourself to reading at least a book a month, one book a month. Okay. So that's 12 books in a year. Now, the international standard for lawyers, for all graduates, not only legal graduates, is that you should be reading one book a week. But that's a bit too much for South Africans, okay? Let's go for one book a month. Now, I gave you some idea of what you can read, but don't worry about that if it doesn't interest you. The secret is to find books that you will enjoy. Never start with a book that you're going to hate. That's a mistake. Find something you enjoy, and don't be a snob. If you like soccer, go read soccer books. You like gardening, read a gardening book. You like romance, read books on romance or science fiction, or crime, documentaries. Autobiographies. All that sort of stuff. There's just a wide world of books. And it is so interesting and entertaining. It's just amazing. What will happen to you if you start reading a book a month? You will definitely progress to a book a week. You'll develop the habit of reading. So what you need to do is create a culture of reading, and you should do it in your homes. Get your children reading. Have books in your home. They must have access to books, okay? You have to read at least one credible newspaper per day. And I mean mainstream newspaper. Don't bother to read, what do you call those things? Like the Daily Mirror or the Sun or the Post. Okay, those are not good newspapers. Read mainstream newspapers. Does two things. It helps with your literacy skills, and it keeps you well informed. Good lawyers are well-informed people. You're always curious. You always need to know what's happening. Okay, so I'm going to move over to questions that you asked. I've got time to deal with those. Yesterday, someone also asked me, well, I've got yesterday's questions. Okay. What I dealt with the introduction one. Yeah, I've dealt with the introduction, and Rehana says discuss fee structure. Now, look. There are two models that are used by firms. Mostly attorneys. The one is called the billable hours model. So depending on your seniority and your expertise, the firm will say you charge X rands per hour. And that varies according to where you are in the firm, whether you're an expert in your field. Those factors are taken into account. So what happens now is that the number of hours you spend on an opinion, you take those hours and you multiply by your hourly rate. Now that doesn't always work, especially with opinion work. The other model, which is brought about by the Act, Legal Practice Act, as well as Consumer Protection Act, is where attorneys are no longer allowed to just charge a fee at the end of when the work is done. Clients are entitled to seek an estimate of the fee before the work is done. They must then indicate if they're happy with that fee, and then that's the fee you're going to charge. Now, if the amount of work you put in terms of billable hours, exceeds the agreed fee, well, you made a loss, okay? Advocates don't necessarily work on a billable hour basis. They see how long it takes and they just give an estimate, or rather they come to a fee. How much each advocate charges? No, you can't tell. There's no tariff as such. They're not bound by any tariffs. Now, what you should do with advocates is ask for an estimate before you brief. What are you going to charge? This is the scope of the opinion. We want an indication of your fee, and then hold them to that. Otherwise, you could get an enormous bill. So that's about all as much as I can tell you about the fee structure. Someone asked, how do you find an easy way to find bylaws? Bylaws are municipal laws. So when you have to consult a municipal law, you will find it. You can Google it, and it's gazetted. Okay, Government Gazette has all the bylaws in it. There are some legislation services, loose leaf services, that provide you with bylaws, but they are very expensive. I suggest the easiest and quickest way is to Google. They all come up. But there's a service, I don't know if it's still on, it's called Prentice Hall. They had all the bylaws. But remember, when you consult a bylaw, remember, it is secondary legislation. In other words, it is subservient to national legislation, which is in turn subservient to the Constitution. Okay, I forgot to mention this word. Whenever you deal with legislation or even the common law, remember we're a constitutional democracy. So your advice can never be anything that might turn out to be unconstitutional. Okay, it seems so obvious, but actually it's not. All right, any more questions, Betty?
None, Judge.
Okay, so I'm going to finish off now. Thank you for attending this course. My final advice to you is, look, the reading, you have to read. If you're not going to read a lot, you're never going to improve your skill sets that we spoke about. Now, this is what I want to leave you with. You must back yourself. You know, we were all not born brilliant lawyers, okay? But you can become one. You must back your own abilities. You must trust yourself, and you must do the work yourself. Okay, that's the important thing. Do it yourself. If you want someone else to check it, good, fine. But first do your draft yourself, give it to someone else to check it. Never copy and paste from somewhere. Just don't do that. Okay. All right. good luck and hope to see you again. Oh, by the way, you need to be fit as well, eh? Physically fit. Lawyers, it's really a stressful job. If you're not physically fit, you are going to get into trouble, okay? All right. Just make a U-turn past the KFC. You'll do better. All right. Thank you. Thank you for attending. I'm going to leave now, Betty.